Good morning to all. Good afternoon. We're very happy to welcome you in Paris, in London, in St. Lucia, and in the BVI in Tortola for this webinar on the international arbitration in the BVI. I just want to make sure that we do have started, and we already have 15 people joining. We'll just start in just a few minutes, waiting for everyone to get connected, and we'll be back in just a few minutes. Okay, I suggest that we start now. So once again, we're very happy to welcome you here in Paris, in London, in Santa Lucia, and in Tortola, in the BVI, for this webinar, interactive webinar on international arbitration in the BVI. Just for your information, but I know you already know that with your past experience in webinars, you have the opportunity to ask any questions you'd like in the Q&A or in the discussion box, and we'll make sure that we address your questions right after the presentation and the discussion between our very learned panelists that I will now present. So we have on the top left of your screen, Angeline Welsh, who is a barrister at Essex Court Chambers in London, and who is a practitioner in international arbitration with more than 15 years of experience. She has been a solicitor for a few years before becoming a barrister in 2015, and she is particularly experienced in the Caribbean region. She has argued cases in the Caribbean courts, and she will share her experience in the matter. Down to the right hand side of your screen is Shan Greer, who is an international arbitrator and a partner at the firm Spencer West LLP. She has more than 20 years of experience advising clients on commercial transactions and disputes, and once again, being admitted in St. Lucia, if I pronounce it correctly, Shan, and correct me if I don't. She has a lot of experience, both as a barrister and a solicitor in the region. She's part of the roster of the International Institute for Conflict Prevention and Resolution, the BVI International Arbitration Center, the Dispute Resolution Center in Trinidad and Tobago, the Dispute Resolution Association in St. Lucia, and the Jamaica International Arbitration Center. She has also been nominated in the CARICOM Secretariat list of arbitrators and conciliators. And she was recently appointed by the Permanent Court of Arbitration in an international oil and gas dispute. Eventually, we have Nicholas Burkill, who is a solicitor in the BVI and who is both the head of the dispute resolution firm Ogier in the BVI and the chair of the BVI Arbitration Group, working in conjunction with the BVIC to promote BVI arbitration. Eventually, to my right, the only person staying here with me in Paris is Hana Doumal, who is a leading practitioner and who is now the registrar at the British Virgin Islands International Arbitration Center in Tortola. She has served in the arbitration field at leading international firms and arbitral institutions in Hong Kong, Washington, D.C., and Paris for more than 8 years, doing both commercial and investor states arbitration. Anna will have a special role as she's both a speaker and will also act as a moderator for this session.
Thank you so much, Raphël. Good morning, everyone in the BVI. Good afternoon in Paris. Let me now introduce my co-moderator, Raphël Kaminsky, who's a partner at Teynier, a leading dispute resolution boutique in Paris. He specializes in commercial litigation, international arbitration, and ADR. He lectures international arbitration at Sciences Po Paris, and he's a member of the New York and Paris bar. He has been one of the co-chairs of the Comité Français de l'Arbitrage, and he's also a board member of the Paris Arbitration Week Association.
Enough of the people, let's now turn to the figures. We would like to share with you a few figures and statistics about arbitration in the BVI and the BVI parties that we have been able to identify in the various major international institutions. Hana, could you tell us a little bit about a few institutions that you're very familiar with?
Absolutely. So let's start in terms of nationality of parties in LCIA arbitrations. We have the statistics from 2020, and we know that 4.8% of parties in LCIA arbitrations are BVI parties. For the Hong Kong International Arbitration, BVI is the third nationality after Hong Kong and mainland China. So it's quite important in HKIAC arbitrations.
Is there a reason for that, Hana?
Yes, it's because it's quite common to see actually Hong Kong entities and Chinese entities creating BVI entities for their businesses. So we see that quite often.
That's very interesting. Just as a comparison, at the ICC, we noticed that less than 2%, slightly less than 2% of the parties are from the BVI, which is quite significant. It represents more than 20 cases per year, and it has represented more than 20 cases per year over the last 5 years.
Absolutely. And for the BVI IAC, unfortunately, we have not released statistics yet. I hope it will come soon, but what can I say? I can say that our most recent cases between two BVI entities, we have seen cases with no BVI parties at all, but with a BVI arbitration seat, a seat in the BVI. And also we've seen cases with one party being from the BVI and the other being a foreign party. So it's quite different. There are different situations that we see.
So we see that for a very tiny island, it's quite impressive to see the number of cases in which BVI entities are involved.
Absolutely. And I will follow up on that and ask Nick if you could please tell us a bit about the BVI and some more about the 2013 BVI Arbitration Act, and maybe explain how BVI courts support arbitration seated in the BVI.
Yeah, sure, thanks. I guess one of the statistics behind the numbers that you've identified of BVI company involvement in arbitrations internationally is that the BVI is home to hundreds of thousands of companies. And so it follows from that a proportion of them get involved in disputes either before the courts or in arbitrations. But just get down to basics about the BVI. You can see a bit of the BVI behind me. That's the commercial port on Tortola. And the BVI is in fact nearly 50 islands, of which Tortola is by far one of the 4 largest and is the largest. And in terms of location, just to make sure that Hana gets back home soon, we are only about 20 minutes by boat from the US Virgin Islands, and that places us in the northeast Caribbean. And politically, and this is important, the BVI is a British overseas territory, so it has an elected House of Assembly elected by citizens of the BVI, but he's under a UK appointed governor who represents the Queen. And consistent with there being several hundred thousand companies incorporated in the BVI, it is one of the world's foremost offshore financial centres. And it is a really well-established centre. You might ask the types of companies that are incorporated in the BVI, being very general about it. They are often used as joint venture vehicles for projects all over the world, and they hold assets all over the world. And you will generally find them, perhaps more than in other offshore jurisdictions, being holding companies with operating subsidiaries below them. And that is an important point to bear in mind when we extend our discussion into enforcement. So that's a very, very quick picture of the BVI. So far as the Arbitration Act is concerned, and obviously that's really central to the discussion that we're going to be having, it's important to understand that the Act is absolutely based on the UNCITRAL model law. And indeed, when you have a look at the Arbitration Act, that is absolutely obvious, because virtually every section of the Act compares itself with the UNCITRAL equivalent provision, and either applies or replaces it in part. So you can see as you go through the statute how closely it follows the model law. One obviously pretty central feature of it is that it created the International Arbitration Centre when it came into force in 2014. Well, it's dated 2013, it came into force in 2014. And again, I won't say more about the provisions of the Acts at the moment, because I suspect we're going to be getting into that in a bit more detail as we progress. But I thought I'd just answer the last question that you put to me, Hana, which is the court support for arbitrations. And there are a number of features, and I think we'll develop this as we go on, but this is a good introduction to how it all works here. Starting perhaps first of all with the interim relief that's available in the BVI, both in support of BVI arbitrations and in support of foreign arbitrations. There is really very broad power to the courts under Section 43 of the Act to grant interim relief, and really very much as you would expect from the powers of a tribunal. They are the BVI courts are capable of delivering very quick hearings. I know Angeline has got one example of that. I've got another example where we started proceedings in the courts last October. We were in trial at the end of January. The trial finished at the end of February, and we had judgment 10 days later. And we've been into the Court of Appeal already. So that's the level of speed that the BVI can deliver, which compares very favourably with, I would have thought, every other jurisdiction in the world. There is certainly a lot of support, both at first instance and appellate level, for arbitration, and is a highly non-interventionist approach to that support. As I think we're going to be talking again later, very ready enforcement of BVI and foreign awards. And then finally, I would say as part of the court support, really important in the BVI is the privacy angle. It always struck me as odd that parties should choose to keep their disputes confidential, but then they become public as soon as they use the courts to support that process. And that's something that the BVI has solved by statute. And then my last sort of introductory point, again, very important, as part of the BVI starting up the arbitration centre and passing the Arbitration Act, the BVI acceded to the New York Convention in May 2014. So obviously that's pretty key to the enforcement of awards in the BVI, or alternatively the enforcement of BVI awards elsewhere in the world. That was all I was intending to say in response to those questions, Hannah. But obviously, I'm hoping that not only will people chip in from the audience with questions, but very happy to open up the conversation as well.
Thank you, Nick. This is indeed very interesting, especially when we compare with Paris, for instance, where we can expect proceedings before the Court of Appeals to last almost 2 years. So when you're talking about a few months, it's really creates sparkles in my eyes, and we're all very excited to hear about that. Thank you very much, Hana. I was wondering if you could tell us very quickly about the BVIC and when it was created and what led to its creation, and explain to us, since you joined the BVIC in January 2021, what you did and what you've been focusing on since your arrival, and what are your priorities for the upcoming months and years?
Thank you very much, Raphël. Well, as just mentioned by Nick, the BVI IAC was created in 2013 by the 2013 Arbitration Act. And you mentioned it, Nick, it entered into force in 2014. So the current 5 members of the board of directors were appointed by the cabinet effective in September 2015. The board is composed of John Beachy, CBE, who is the president, Mark Forte, Shan Jalal QC, Murray Smith QC, and Felice Swap. I need to mention also Toby Landau, QC, who is an advisor to the board, and mention the Honorable John Smith, who is now the Attorney General of the BVI, but who was a former advisor to the BVI IAC, to the board. The CEO was appointed and started on the 1st of May 2016. It's François Lassalle. And at that time, there was a soft opening of the center. There was no facilities yet, and François had to work on that. And it actually opened for cases and for business, the building of the center in Tortola on the 1st January 2017. The team, I have to mention, is composed by the CEO, François Lassalle, the center manager, Janet Bryn, with whom I co-host Arbitration Life, and our senior administrative assistant, Chantal Gray, who helped us organizing this webinar, of course, and who helps us with everything at the center. So now just to focus a bit on the BVI IAC, it's an independent not-for-profit institution that was established to meet the demand of international businesses for neutral, impartial, efficient, and reliable dispute resolution institution in the Caribbean. There was no such institution at the time, and the BVI saw that there was a need for it, as mentioned by Nick earlier. Now telling you more about the institution, the facilities itself, it's a very well-equipped state-of-the-art center, which has the acknowledged quality of the BVI legal framework and the stable political environment, which is offered by us being a British overseas territory. The goal, of course, of the BVI IAC is to become a leading arbitration hub in the Caribbean and beyond, hence the title of this webinar. So to answer your question about my focus, since I arrived, I can say proudly that I've been hitting the ground running because I've been working on managing the cases. We had a number of new initiatives, including Arbitration Life, cooperation agreement that we signed with the Hong Kong International Arbitration Center, as well as Arbitral Women, and we're working on a few others at the moment. A number of articles and publications, notably in the New York Law Journal, Corporate Disputes and GAR. We've been engaging with the BVI arbitration community. I have, with the team, worked on that quite a lot. And for that, I would include the BVI Arbitration Group, and Nick is the president of the group. And we being quite active at the moment to promote arbitration in the Caribbean in general. And we also, we have been working, and I will develop that a bit later, on the amendment of the BVI IAC rules of 2016. So we'll have new rules before the end of the year. We've also been working on the organization of webinars, this one and others to come with the BVI Arbitration Week that will take place in the first week of November.
This year of 2021.
This year of 2021.
Very exciting.
So, yeah, in less than 2 months. And I would say my main priorities for the upcoming months and years would be, obviously the BVI Arbitration Week. It will be held remotely for the audience who's asking, thinking right now, can I come to the BVI to see the conferences? Unfortunately, no, it will be held remotely because of the current pandemic, but we'll see, maybe in 2022, hopefully it will be in person. I mentioned the new rules, so I'm focusing on that as well. And just engaging with the community in the BVI, in the Caribbean in general. We'll do a roadshow next year in 2022, as well as continuing developing new initiatives. I will quickly mention Cadren, which is an initiative created by Shan, and she will develop that a bit later. But we've been working quite closely to develop ADR in the Caribbean. So yeah, I'm very excited to see this institution growing.
It is indeed. And if I may, we received a question in the meantime about what arbitration sector expertise do you see the BVI Center developing? Mining, M&A? I see a clear potential for tourism-related disputes in the Caribbean, but what others do you see and what current sectors are utilizing the BVI Center? So maybe Hana or some other panelists would like to address this question?
For the center, I can quickly answer. I mean, there's a very different variety of industries in our arbitrations. We haven't released statistics, so I can't be very precise. Yeah, tourism is one of them. M&A is quite classic. I would say this is probably the most, the type of dispute we see the most. But yeah, maybe Nick can give a few examples of.
Yeah, I mean, one of the reasons why I identified the use of BVI companies as joint venture vehicles is, of course, that that then produces the joint venture disputes. And we see a number of those in the courts, and I would have thought that they will be coming into the arbitration centre as well. But I think that there's also a geographical issue as well, which is the BVI in the northeastern of the Caribbean is well placed from a time zone and from simply by location for dealing as a neutral venue for a number of disputes from particular parts of the world. So you could see, for example, South and Central America and North America and Europe even using that as a neutral venue, extending out to Russia and neighboring states. And then, of course, finally, although not convenient geographically for the PRC and Hong Kong and Asia, the fact is that PRC and Hong Kong entities have used the BVI for corporate vehicles really, really extensively. And so I would have thought we would be expecting to see some an extension of that geographical expertise that we have there.
Yeah, if I can, Hannah, I think from a Caribbean perspective, given the developments in Guyana, and particularly the impact that the pandemic has had on businesses within the region, we're probably going to be seeing a lot more oil and gas disputes and a lot more disputes between regional entities and international entities. And I think these sorts of disputes are probably ideal for resolution through the BVI, because it is in all respects neutral, even though it's in the Caribbean. The islands that I'm referring to tend to be a little further away, and it's sort of ideal. It gives everyone the benefit of neutrality. So I think there is a real possibility that we're going to see, and certainly we're seeing it already, of disputes falling into those categories.
Yes, that's right, and that's independent, of course, of the of companies incorporated in the BVI. So these are companies incorporated in other jurisdictions.
Yes.
Thank you so much. We had another question from John. Though I'm going to ask a question to Angeline, who will answer your question. So I'll just go for it. And then, John, if you have something to ask later on, please feel free to. So, Angeline, what advantages do you think BVI arbitration offer?
Right, and I can see that John's question is, what is the BVI's USP? So maybe I'll start and tell you what I think the USP is, and then, but Hannah, of course, you may have different views. In preparation for looking at what makes a good arbitral seat, I started at the place that most arbitration lawyers when preparing a seminar would look to, which is the White and Case and Queen Mary International Arbitration Survey, and the one that came out this year, because that asks the question, who are the leading seats and what is required in order to be a good seat? And the list of leading seats is not will not take anyone by surprise, and of course London always ranks pretty highly. What would make a good seat? Well, the answer to that is greater support for arbitration by local courts and judiciary, increased neutrality and impartiality of the local legal system, and the better track record in enforcing agreements to arbitrate and arbitral awards. They're the key adaptations. So what is the USP? Well, I would say that BVI as a seat meets the standards which is imposed by London, but has some further pro-arbitration adaptations on. So even though it's a relatively new seat in the sense that the arbitration law was enacted in 2013, and the centre is relatively recent. What it essentially does is piggyback off on the wealth of authority and experience that we have from other jurisdictions, and in particular London. And I'm going to explain why I say that. So the first thing I think to be clear is that looking at these adaptations, and some of these points have already been made by Nick, so I won't try not to repeat what Nick says, but you have in the BVI a neutral and experienced judiciary. That is one of the key requirements of a well-established seat. And also you have great support for international arbitration. So one of the things that we have seen through the introduction of the Act is there have been a number of cases now which have come through the BVI courts where the judiciary has made it very clear that the new Act established a new arbitral regime, which was where the courts would be very supportive of arbitration and not intervene unless necessary to support the process. So one of the, I wanted to quote from Ogier, as then was in Retribution Limited and L Capital KDD and Limited, which is a High Court case from 2015, which concerned an application to set aside an order for winding up on the basis that the debt was disputed. But the point that was taken in that case was that debt was to be resolved in arbitration proceedings, and that had to be dealt with before the winding up. And what the judge said in that case is, it is my view that section 18.1, which is the provision for applying for a stay of court proceedings in favour of arbitration, coming as it does in modern arbitration legislation, which seeks to create and provide a comprehensive legal and modern framework for attracting and dealing with arbitral disputes from around the world, and to provide the platform from which to launch BVI as an international arbitration centre, was intended specifically to limit further the jurisdiction and power of the court to intervene in and determine matters which clearly fall within the four corners of an arbitration agreement, by which the parties have decided, as a matter of contract, to have all disputes determined only by arbitration, however minor or indefensible their dispute or difference may be. So it's a very clear direction that the courts will not intervene in arbitration. And we've seen that in subsequent cases. And one that would perhaps be worth highlighting is a Court of Appeal decision, Khashoggi Limited and Donna Union Foundation, where the question was, should the court, the BVI court, issue interim relief in support of a foreign arbitration? And the court had no difficulty in deciding there was power under section 43 of the BVI Arbitration Act to grant that interim relief, including in relation to enforcement of awards, and there was no need to show that there are assets in the jurisdiction or to resort to the common law in lieu of the statutory basis. So what we now have a few years of cases coming through the courts post the introduction of the Arbitration Act and BVI, where it's very clear that they're going to follow a robust pro-arbitration approach. And one of the things that I want to say was the relationship about English law, because I think as I tried to describe the way I would put the USP, which is that some ways you might say it's London with bells on, is the relationship between the BVI and English law. The fact of the matter is BVI, like many jurisdictions, Commonwealth jurisdictions and other jurisdictions in the Caribbean, draws on a deep reservoir of English case law, because while there are some differences between BVI and English law, originally English law, common law was adopted into the law of BVI, and while it is not binding precedent, it's often very persuasive in terms of the judgments. And so you are not dealing with a jurisdiction where there's no precedent or guidance in terms of how to approach some of the more difficult issues of arbitration law, which have come up over the years. There's already there, as I described it, a deep reservoir of case law to draw upon. And we can see, and that is reinforced by the fact that the final Court of Appeal for the BVI is a judicial committee of the Privy Council, which comprises the same judges as the Supreme Court in England, That's the same for another of other Commonwealth jurisdictions, and they are dealing still now with a lot of important points of law, arbitration law, which are new, which will actually, in fact, influence English law. A good example of that is the Better Max Limited and State Trading Corporation case from June this year, which was an appeal from Mauritius, and that considered the extent to which a court can set aside or refuse to enforce an international arbitration award on the basis it conflicts with public policy, which is an important point, but actually doesn't come up too much in English law. I was going to say something very briefly, if I'm not talking for too long in this section, just about what are the adaptations which BVI has made, which goes beyond English, the English Arbitration Act. And one of the key ones, I think, is the issue of confidentiality, which is something which Nick mentioned in his introduction. In English law, when the 1996 English Arbitration Act was brought in, the DAC, who were looking at what should go into the English Act, decided that they wouldn't tackle confidentiality. And they did that because they said, actually, you know, it's very difficult to set out all of the exemptions to the absolute obligation or conditional obligation of confidentiality in English law. So they didn't attempt to do it. In BVI, the BVI legislature has actually set out those exemptions. And in fact, what they've done is set out a fairly robust regime for maintaining the confidentiality of arbitration proceedings and court proceedings relating to arbitration. So just to sort of flag some of maybe the way in which the BVI court would approach the question of confidentiality when proceedings are commenced relating to arbitration, which is different to the way in which the English courts would approach it. So far as English law is concerned, once a party has stepped foot into an English court in relation to arbitration proceedings, there is, for the most part, a presumption that the hearing itself will remain confidential, although that differs if you're dealing with a point of law. But after that, a party may apply for that hearing to be made in public. And then there's always a question, the extent to which the judgment should be published. And there is said to be a sliding scale, because while parties who have an arbitration agreement assume that their matter will remain confidential, there's also a public interest in knowing that arbitration proceedings have been conducted properly. And so the courts say that that's something that one has to weigh up in deciding whether or not to not publish the judgment, or more commonly, whether you anonymise the judgment. Whereas under the BVI system, the position is almost reversed in the sense that it is presumed that that there will be confidentiality. So Section 16 of the Arbitration Act in the BVI requires that unless there is a party agreement, no party may publish, disclose or communicate any information relating to the arbitral proceedings or the award, and then goes on to stipulate some of what we would know to be the usual common law exceptions. So unless to pursue a legal right or interest, or to any, unless directed to produce the information by a government body or regulatory body or court, and so on. But when it comes to court proceedings, the court is required not to make an order for publication of judgment unless the parties agree that it can, or publication would not reveal information which the parties could reasonably consider to be confidential. The BVI court can still depart from this regime, but only where it's in the public interest to do so, or a major legal interest. And so you start almost from the reverse position, which is that there will be a presumption of confidentiality, and it will only be, while the circumstances in which the judgment will be made public are not too dissimilar from England, one would have to justify it, rather than, as is the case in England, you have to conduct a balancing exercise at the outset. So that, I think, is an important departure from London, and it would be a departure which many people who arbitrate their disputes, who expect them to maintain confidentiality, would regard, I think, as being important. So,
can I just, sorry, maybe there was a delay. I wasn't sure that you had finished, Angeline.
No, go ahead.
Yeah, I just wanted to jump in with certainly one background point which helps with the BVI as a jurisdiction. Now, we've been talking about the appeal court, and the appeal court is for the Eastern Caribbean, so it extends beyond the BVI to a series of jurisdictions and territories. But one of the really interesting things about the Court of Appeal is that is the BVI influence on it. So the current Chief Justice is a BVI lawyer, and two of the senior Justices of Appeal are BVI lawyers. Justice of Appeal Ferrara, who Angeline cited, and Justice of Appeal Webster as well. And it's interesting that the BVI does have that influence, and we can expect that to be reflected in the Court of Appeal judgments on this as well. I just thought it'd be interesting to add in that bit of color, local color on what you were saying.
We appreciate Nick. Angeline, were you done with what you wanted to tell us about?
Yeah, that was it. No, over to you.
Okay, thank you so much to both of you. Hana, just following up on what Angeline told us, I was wondering if you could give us more insight about the BVI IAC rules, please.
Absolutely. So our 2016 rules are modern UNCITRAL-based rules. Quite classically, I mean, they follow the UNCITRAL rules, and we even have on the website a version in track changes. So you see that it's very much inspired by that model. What I think I will give you more insight on, though, is the new rules that are going to enter into force in November 2021. So we've been working this year since I joined with a Rules Amendment Committee composed of Shan Tang, Shan Bao, Christine Artero, Victor Bonin-Renes, and Thomas Granier. And they've been working very hard to review the rules and propose new amendments to make us a competitive institutions with all the provisions needed for arbitration users. So there will be, and you'll see when we present the rules during the BVI IAC Arbitration Week, again, that will take place on the first week of November. Don't think I'm making like publicity for the BVI IAC week. I may though, but so yeah, we'll do a session to present the rules more formally, but what I can tell you is that we will introduce new provisions on emergency arbitrator, expedited procedure, the role of tribunal secretaries, joint consolidation, as well as we will introduce an arbitration committee to ensure the application of the rules.
A state-of-the-art arbitration rules setup.
Hopefully.
Excellent. I think we have a first attendance coming in today in Paris. We are full of surprises. Mr. Shai Sharvit from Israel joining us live. You can have a seat, Shai, anywhere around the table. You're a bit late, but Hana, I think you had a question for Shan.
Yes. So Shan, what do you think are the benefits of arbitrating under the BVI IAC rules or using the BVI IAC as appointing authority and also using the BVI IAC beautiful facilities? Shan, you muted.
Making the classical mistake, my apologies. So, as I mentioned, as Raphël mentioned, I am from the Caribbean island of St. Lucia, and we're most known for our beautiful beaches and the world's only drive-in volcano, but certainly not for international arbitration. And I think up until about 10 years ago, this was probably a fair comment for most Caribbean islands, including BVI, because small island states and developing nations in the region lack the capacity and regulatory framework to administer international arbitrations effectively. Now, today, the Caribbean landscape is very different. I think it's fair to say that the creation of the BVI Center is arguably one of the first significant developments in the region. And since its establishment, the center has quickly made a name for itself, both internationally, and it's carving a place in the market. In addition, the center has improved the region's visibility, and the Caribbean is earning its place as a potential seat and a market for international arbitration. Now, this leads me to the question that you asked about the benefits of choosing the BVI Arbitration Center. And given that the weather is starting to cool down and Europe is heading towards winter, it's tempting to highlight the obvious, which is that BVI has sea and sand. But while that is an advantage, and I just finished an arbitration in Barbados last week, and it certainly is nice to be able to go back after a hearing to your hotel room with a sea view. But I know that from a practical perspective, that falls very low on the benefits ranking of the BVI. Now, I thought about how I could unquestionably and measurably demonstrate the benefits of choosing the BVI. And as every lawyer knows, a fact is only valuable if there's evidence to support its truth. So I decided, it'd be prudent to find an international standard that we could use to objectively prove to you that BVI is the place that you should use for arbitration, including the center. And that when I do mention the region, you would think more than just sea and sand. And in 2013, the Chartered Institute of Arbitrators established 10 principles, which they argued could be used to determine if a jurisdiction was attractive as a seat. And of those 10 principles, Nicholas, Angeline, and Hana have already addressed several of those, including an effective and modern arbitration law, an independent judiciary, an independent competent legal profession with expertise in international arbitration, and of course, an easily and accessible safe seat. So I'm going to focus on some of the other principles in the hopes that we're able to convince you that BVI can hold its weight, and that using the center is certainly advantageous to the arbitration industry. Now, one of the principles is that they have a commitment towards education of counsel arbitrators, judiciary experts, and users of arbitration. And I think on that front, the BVI International Arbitration has through the years demonstrated a commitment to education, in fact, from the date of its creation. At the first conference, it sponsored CIARB membership training, and several persons from the Caribbean region had the opportunity to achieve member and fellow status as a result of their efforts. The center also sponsors various nonprofit organizations, including Cadrin, who promote arbitration, and both Francois and Hana are household names in the arbitration circuit in the region. In October 2020, the center ran a mock virtual hearing, which was exceptionally well attended by ADR professionals, not just in the region, but internationally. In fact, we had participants both from Europe and Africa, just to give you a sense of the extent of its reach. Further, as Hana mentioned, the center regularly publishes in arbitration publications like GAR and Corporate Disputes. So to my mind, I think I would feel fairly comfortable in saying that, we've ticked that box. Another important factor to take into account is the right of parties to be represented at arbitration. And under Article 61 of the BVI Arbitration Act, parties are entitled to be represented by legal practitioners of their choice, and there are no limitations. So parties don't have to choose a BVI attorney. Having said that, there are numerous firms on island who are more than competent to represent parties. In terms of functional facilities, which of course is always important, There are several large hearing and meeting rooms, as well as a designated lounge, which has an amazing sea view, much like the one in Nicholas's background. And certainly in between hearing, it's a nice place to, reset yourself. So, which I'm sure there aren't very many arbitrations that may have that benefit. So I'll throw that in as well.
John, can I just say that my office is just a couple of floors up from the arbitration centre?
There you go. So that is literally the view you're going to get. Right. An important factor, and one that is particularly had focus in the past few years, is that the center embraces diversity in legal and cultural traditions and in developing norms of international ethical practices. Now, both the rules and the Arbitration Act are cognizant of the need for arbitrators to act impartially and independently, and the center is committed to international best practice on issues relating to ethics. More importantly, the BVI Center has a diverse world-class roster of arbitrations, and not only are its arbitrators competent in a wide variety of industries and sectors, but the list is also sensitive to the need for diversity and includes both women and people of color. Now, I know that they have cheated someone because when they choose people like me who tick more than one of those boxes, but I'm not going to be too hard on them, just if only for self-serving reasons. But I think that it's important that the center, given that it's in the region, that is used as an opportunity to showcase the region's talent. And I think that they've done a good job of doing that. The last two principles are adherence to international treaties, which allow for the recognition and enforcement of agreements and awards. And as Hana and I believe Nicholas mentioned as well, the Arbitration Act is UNCITRAL model law compliant, so it has all of the provisions which deal with the enforcement of agreements and awards, and BVI is also a signatory to the New York Convention. So any party who's using the center and or BVI as a seat can feel fairly comfortable that their award's going to be enforceable. And the last, which is one that's generally overlooked, and it's probably not so much for the parties, but for the arbitrators themselves, which is the concern about arbitrator immunity and civil liability. And the Act does provide that level of coverage. So if I were formally presenting, this is the part where I would, give my strong close, but I think that the evidence that I hope is submitted, that won't be necessary. On a serious note, though, I think it would be naive of us to pretend that there isn't legitimate competition in the arbitration space. And, we understand that there are institutes who have been here, as we would say in the Caribbean, since Adam was a little boy. But nevertheless, what we're hoping you're going to take away from this webinar is a snapshot of what BVI has to offer and the reasons why it should be considered by the arbitration community as a viable option.
Thank you, Shan. In the meantime, we had quite a related question from John. Thank you, John, for all your questions. We much appreciate. He was asking whether the BVI arbitration law adequately supported the use of remote hearings. I don't know if Nick, maybe you had an answer to this question.
I certainly should have more of an answer than the very broad answer I have, which is yes, absolutely. Because I wrote an article on this subject a couple of months ago, and the detail of it isn't quite at the top of my mind. But the good news is that we have another conference, another webinar that we're going to be doing at the end of November on opportunities arising out of the pandemic, and remote hearings is exactly one of those topics that will come up. But I should perhaps also say, again, in connection with the court support for the centre, remember that a few days more than 4 years ago, the BVI suffered a really very serious hurricane, and the result of that is that the BVI, years before the pandemic hit, had become used to the concept of remote hearings, and so when the pandemic did hit, the Chief Justice simply had to sort of brush off her practice direction for the BVI from a few years prior, and we switched straight into remote hearings. I think a long time before before a number of the onshore jurisdictions, because it's something that we were used to. And so that's a long way of saying, yes, the BVI is well used to remote hearings, although the fact is that people do like coming out for hearings.
As a matter of fact, because I can just reinforce your point, the mock hearing that we did in 2020, we actually went through all of the advantages and how we run it, how the center runs it virtually. And I believe, and Hannah can correct me if I'm wrong, that is actually online on the website. So you can go.
Absolutely, Shan. Yeah.
It's on the website, and
website.
How they run and the technology that's used, and we essentially walk you step by step through the entire process. Yeah.
Yes, and we've been used at the center to do remote hearings, so that works. I mean, all institutions have been used to do that for the past 2 years, so we are equipped.
Angeline, we're running a bit out of time now, but I'd like you to present very briefly what we call the Pakistani airline case that has been very publicized recently with several BVI court ruling that seem to be a very good illustration of the very arbitration-friendly approach of the BVI courts. Could you maybe give us a few words about this case that I believe you've argued before the BVI courts?
Thank you, Raphël. Well, in some ways, this is a really important case, which I think is the first time that someone has sought enforcement of an ICSID award in the BVI. It's primarily important, I think, because it deals with enforcement against states and of the various issues which arise. This was a case where it's all in the public domain. Teynier Copper Company has an ICSID award against Pakistan, which is subject to revision proceedings at the moment. And TCC got some ex-parte orders in December 2020 against Pakistan for recognition of enforcement of the award, but in addition got provisional charging orders over shares held by one of the airlines in Pakistan International Airways, the shares that they held in 3 BVI companies, and an interim receivership order. So Pakistan applied to set aside the orders on the basis that they hadn't waived their right to immunity from the jurisdiction of BVI, and also that they hadn't been served. The other entities also contested the orders, but on different bases. Pakistan International Airways on the basis that they couldn't be assimilated with the state for the purpose of enforcement against their assets. And the BVI company said that the injunction should be set aside because no evidence of dissipation, and all argued that TCC was in breach of its duty of full and frank disclosure for not raising some of the arguments which should properly before the court when it sorted its ex-parte relief. And ultimately the court at first instance agreed with the respondent companies and set aside the recognition and enforcement orders and the other interim orders which had been obtained. So in some ways you might think immediately, well, is this a very good example of a case which is supportive of arbitration because the orders were set aside? But the one thing that I would like to really highlight about this case was that the way in which the court dealt with the complex issues which had arisen, and then there was a very short application to the Court of Appeal for interim relief by TCC, which was declined. They dealt with it incredibly quickly, I think, because the orders were obtained in December 2020. There were 6 sets of counsel to negotiate. Various interim hearings, and the final hearings were heard in April, and the judgment issued in May. Then there was an application to the Court of Appeal for interim relief by TCC, which was declined. So that was all dealt with very quickly. And the judgments which were issued, I think, are really important judgments dealing with sovereign immunity issues, which I'm sure will be referred to in the English court, for example. So there's an example of where BVI court is dealing with difficult issues which would be referred elsewhere within the Commonwealth. At first blush, you might think, well, it's not a supportive arbitration decision, but actually I would argue that it shows that what you have in operation at the seat is a very impressive court which can deal with tricky issues very quickly. And I should say that the first instance judgment is currently on appeal. And I also just want to say 2 quick things, because I know we're running out of time. One is that there were several hearings on this case, and I'm also doing other matters in BVI. They were all heard remotely. There was no difference between doing remote cases in any of my arbitration hearings for the Commercial Court in London or in the BVI. It was incredibly impressive. And as for the remote hearing point, I mean, I personally struggled to see what the difficulty would be with having a remote hearing when the seat is in BVI, when the courts were operating all the hearings on a remote basis. And there's nothing in the English law specifically which deals with that point. I'd be interested, and so I don't see why BVI law would have to have something, and I'd be interested to see whether there are going to be any adaptations to BVI rules, because I know that some recent institutional rules have slightly tweaked their provisions just to make it clear that there's no problem with remote hearings. So that's all I'm going to say about those particular cases and what I've learnt out from that. So back to you.
Thank you, Angeline.
Thank you, Angeline. On that point, absolutely, we will make extremely clear in the new 2021 rules that we provide remote hearings, and we are equipped for it. In the 2016 rules, it was implied, and we already had remote hearings. But thank you for mentioning that, Angeline. Yeah. And
quickly, a question for you, Nick. Again, in the interest of time, I will simply limit your response to a few minutes. But we've asked you earlier about the BVI court support. And would like you now to speak very quickly about the enforcement. You've already mentioned that it was an arbitration-friendly jurisdiction in terms of enforcement, and I'd like you to give us a few more details about that in just a few minutes.
Sure, I'll give some real headline points on that. And again, you can compare the BVI Arbitration Act with the Unstral model law, and whilst there are differences, they're more on this particular point, whilst there are differences, they are not really material differences, whether it's talking about the enforcement of convention awards or non-convention awards. There's some changing of the hearing, of the order of things and so forth, but very much compatible with the model law. I would say, and this is consistent with the Pakistan case, that the enforcement by the BVI courts is very swift. In my experience, you can lodge papers seeking enforcement of a foreign arbitration award and expect to get something back from the court within a couple of weeks. And that compares obviously very favourably to the enforcement in a number of jurisdictions of court judgments, where in the BVI in England, in the United States, amongst other places, you'd expect to have to institute fresh proceedings pleading the fact of the foreign judgment as the basis of your action in the country where you want to enforce. And then finally, on the types of enforcement that are available in the BVI, bearing in mind that BVI companies, if you're enforcing into the BVI, are often holding companies. What you really want to do is, as the beneficiary of an award, is take control of that holding company through the shares. And at its most extreme, the BVI will appoint a receiver over those shares, and that then trickles down the control through the group. And it's really a highly effective way of enforcing an award. There's more, but in the interests of getting people away on time, that was all I was proposing to say.
It's not because we have an opening cocktail that we're saying that down here in Paris.
I'm absolutely sympathetic to that.
Hana, I think you still had a few questions for Shan and Angeline.
So Shan, you are the co-founder of Cadrin, and I mentioned that earlier. Cadrin is an initiative to develop ADR in the Caribbean region. Could you please tell us more about Cadrin in a few words, 3 words maybe, like
all right, no
3
problem.
big ideas for Cadrin?
Well, in a nutshell, as I've mentioned earlier, there's been a lot of development in the region, and that has been a result of campaigns both by international institutions and regional ones like the Chartered Institute of Arbitrators, Institutral, BVI, Impact, CARICOM. And the difficulty we found was that while all of these persons had the best of intentions, there wasn't a coordinated approach. So our vision with Cadrin is to establish a platform for regional practitioners, ADR centers, and potential users to come together and discuss international best practice and collaborative approaches to promoting ADR in the region. Our first 2 years have been challenging because of COVID, but we've done a lot of work both with the center and with other organizations to have virtual sessions. This year, we're going to be focusing on SMEs and how to effectively resolve their disputes within the region, as this was an issue that was identified in the arbitration report that was produced by the Commonwealth. So those are some of the initiatives that we have. More information about what we do and how you can get involved is on our website, which is cadrin.org.
Shan, that's very interesting. Last question, Angeline.
Sorry?
And I said, I hope I met the time. I think I met.
That was perfect. That was in a nutshell. Cadrin.org, the website. Look it up, please.
Angeline, and this will be our last question, unless the floor has further questions. You've acted as arbitrator in a BVI IAC case. And of course, we're mindful of confidentiality here, but we would like to know more about your experience of the institution. And could you briefly, and I insist on briefly, explain what you consider to be the pros and cons of the BVI IAC for an arbitrator?
Thank you. Well, I think I have the distinction of acting as arbitration, the first BVI administered arbitration several years ago now, which of course was my great honour. I think the BVI IAC operated to, exactly the same very high standards as you would expect of any other major arbitral institutions. Very cost effective in terms of award review, very prompt review, which was quick and sensible, and very sensible and professional communications with the parties and the arbitral tribunal. And in that case, we didn't have a hearing because the parties were content for matters to be dealt with on the paper. So I sadly didn't get the opportunity to come to Road Town and sit in the BVI IAC itself, but I have visited previously, and I can endorse other comments that it is rather beautiful. So absolutely would recommend it.
Thank you very much, Angeline. do we have any question either from the floor or from the panelists on any of the issues which were covered today?
Raphël, whilst we're waiting for questions from the floor, can I do one shameless plug for the BVI Arbitration Group?
Of course.
I can't pass this opportunity without promoting it. Its details are on the BVI IAC website, but basically we are a group of professionals, not just lawyers, who are interested in arbitration and interested in promoting arbitration and BVI arbitration in particular. We work in conjunction with the centre in doing that. It's a great opportunity to get people together. I regret virtually at the moment, but and we have an educational function as well. And many of our members are international members, not just based in the BVI. So go onto the IAC website and have a look at the details there and become a member. It's free.
Nicholas, thank you very much. Thank you, Angeline. Thank you, Shan, and thank you, Hana, for co-hosting this webinar with us. I think it's a good illustration of the diversity of the events that take place at the Paris Arbitration Week. As you've heard, we've not heard much about Paris today. And this is also part of the diversity that we want to share during this week. So I'd like to thank you all for your time today. Thank you for all the participants and for all your questions that you've sent us. And we'll have the pleasure to be in touch very soon on other occasions in Hana with the development of this new arbitration center in the BVI. See you soon, and thank you all for participating. Have a good day.
Thank you all, and
thank you so much,
Raphël, for having me in Paris and for co-hosting this webinar.
Pleasure.
Thank you all.
See you soon.
Bye.
Bye.
Bye.